One of the big areas for accommodation analysis is when, whether, and to what extent leave is a reasonable accommodation, and when does leave as an accommodation become an undue hardship. As we've already kind of looked at, both the ADA and human rights law regulations recognize that modified work schedules might be a reasonable accommodation in some cases. Also, both the EEOC and the New York State Division of Human Rights take the position that some period of time off might qualify as a reasonable accommodation. Like other accommodations, you must weigh the factors to determine whether leave poses an undue hardship to the employer. And it is very important to recognize and remember that satisfying the FMLA, where that applies, paid sick leave laws, like in New York City now, for example, where they apply, and other legal requirements, does not preclude the possibility that additional leave would be considered reasonable. So the clearest case is an individual who has been out of work for 12 weeks under the FMLA is not then able to immediately return to work. Obviously, the FMLA gives qualifying employees 12 weeks of leave, after which they have a right to reinstatement. After that 12 weeks, they might nonetheless be entitled to additional leave as an accommodation under the ADA or the human rights laws. There are still many employers who don't understand that and believe that once the 12 weeks is up, then they can send out a termination letter saying, thanks, maybe you can reapply, but for now you're off the payroll. Those cases are historically popular with the EEOC and New York State Division of Human Rights, in the sense that you are going to draw their ire if they see that happen in a set of facts that is brought before them, and they are going to pay attention to that case, and they are going to pursue it more aggressively than they might others. At least that is my experience with that issue. So there needs to be some consideration, for example, after the 12 weeks, as to how much longer the person needs to be out, and then whether that is an undue hardship. Related issue, while I'm on that particular point, is the concept of maximum leave policies. The EEOC historically has opposed employer policies that set a specific maximum leave period. Commonly, these will say, employee may be eligible for an additional leave of up to 6 months or 12 months. Sometimes it's 2 years. I've seen some that are 3 months or less. The reality is that the EEOC and Division of Human Rights don't like those absolutes, because they look back at all of the laws and regulations and say that basically you have to consider multiple factors in deciding what's reasonable and what's an undue hardship, and bright lines don't consider multiple factors. The courts sometimes actually uphold these types of policies, so I'm not here to tell you that you can't have them, but they will be scrutinized by the state and federal discrimination agencies. What is probably the better practice and safer approach, therefore, is to have sort of a maximum guideline with the possibility of extension of the leave for some reasonable additional time period. So, for example, a policy that allows an employee to be on leave for up to 6 months, probably better if it's 12 months, but different situations might justify shorter periods. So you can be out for up to 6 or 12 months, and then if you need additional short periods of leave, then provide information and we'll consider it. I mean, I wouldn't word the policy that way, but that's basically the gist of it. Then at, or preferably a little before the end of the guideline period, the company would engage with the employee to get the information as to when and whether the employee will be able to return to work and perform the essential functions of the job. Again, with or without some other form of reasonable accommodation. And if the employee is going to be able to return next week in full health, then it would be unwise to rely on the 6 or 12 month, whatever it is, period to suddenly end their employment. But if they're still going to be out for an indefinite period of time or a long period of time, that's when you would then make the undue hardship analysis and determine whether you would have to then say, I'm sorry, we need to fill the position or whatever, otherwise move on, but you're happy to apply in the future if you're able to return to work.